Welcome to the Bringing the Human Back to Human Resources podcast. I'm Traci Chernoff, and I've spent my entire professional career in HR. Each week, we'll explore the delicate balance between people and business with the aim to reconnect the two and create meaningful outcomes. Listen in as I share my own experiences, challenge the status quo, and chat with guests from various industries about our mission to bring the human back to human resources. Hi, everyone. Welcome back to the Bringing the Human Back to Human Resources podcast. Don't forget to rate, review, and subscribe wherever you're catching this episode, whether you're watching or listening. This is another Policy Pulse segment. I feel like I need the breaking news alert sound, like because this is a monthly episode cadence for us, and us meaning, if you're new here, this is Bryan joins me. He is an attorney, and he is kind of our resident expert in all things law, but don't forget, he is not giving you any legal advice, so make sure you seek your own attorney, okay? Bryan's mine, you can't take it. No, I'm just kidding. But seriously, seek your own legal advice. This is us just talking about things that might be relevant to you, and actually probably are very relevant to you, especially if you have a US-based workforce. And so every month, as you hopefully know if you've been listening, we take this Policy Pulse episode and we talk about all of the things that you should have a pulse on from a policy standpoint. So this month, we're going to kick off the Policy Pulse episode talking about the Department of Labor. Their ears must ring because we talk about them a lot. And so we are going to talk about the emergency pay that now must be included in overtime. So in a new opinion letter, the Department of Labor determined that emergency pay, extra compensation for work performed during declared emergencies, must now be included when calculating overtime under the FLSA or the Fair Labor Standards Act. The case involved a city that paid firefighters a 50% premium during emergencies. The Department of Labor ruled that because the policy guaranteed the premium in advance, it wasn't discretionary and had to be counted in the regular rate of pay. Bryan, can you break that down for us? Tell us a little bit why it matters, what we should do, how this impacts us.
Yeah, so generally speaking, employers tend to, and many times rightfully so, take the base wage for an employee. So say it's $10 an hour. Overtime for that, 1.5 would be $15 an hour. Easy math, right? So any hours over 40 would be paid at $15 an hour instead of 10. Except if there's some type of supplemental pay. Emergency pay, hazard pay, shift differential, those are three of probably the most common. Those are calculated in the base pay. So if someone makes an additional $1 an hour for emergency pay, and they work 10 emergency hours during a certain pay period, for those 10 hours, their base pay is $11 an hour. So now you have to average over the entire calculation. This becomes much more complex now, because your 1.5 on the base rate is going to be different because the base rate itself is different, because it needs to be calculated including the emergency pay, the hazard pay, whatever supplemental pay is being offered. And that's where actually you can use software that is really helpful with that. Lots of payroll software can automatically calculate that for you based on your location, based on the location of the employee, where they're working, the type of pay that you're giving them. It will automatically calculate the overtime rate based on the adjusted base pay rate for that particular pay period. And that was a lot of words to say, essentially the base pay becomes different when people get supplemental pay. That's the ultimate story there.
No, it's interesting. If I'm understanding correctly, in the event of an emergency where someone is receiving this type of hazard or an emergency pay, it impacts their base rate at the hourly level, and then the overtime is calculated based on that new rate.
Correct.
Right? That's really interesting. It makes me think about COVID and all the people who received hazard pay and how that was, kind of calculated. Overtime was not calculated on top of that hazard pay. It was separate, basically a separate line item.
Right.
And there were also a lot of people who are not overtime eligible who did not get hazard pay. But I'm just saying, I know a few people who are salaried and did not get hazard pay during COVID. But anyway, that's interesting. I hope that HR teams have really strong payroll support, because the complexity of that, and what I would imagine is the exposure in not properly calculating, is quite significant. So for teams actually who are smaller and maybe don't have payroll support, they're just probably outsourcing this to their payroll provider, which is fine. But I do think that HR leaders need to be really clear on this. So whether they are part of a small team or a large team, they do their due diligence in making sure that things are calculated correctly. That's,
And to your and to your point about outsourcing it too, even if you are outsourcing it and you trust the vendor to calculate all of this correctly, it's still ultimately on you, the employer, to verify the information, to
right.
verify that it's calculated correctly. So you still need to know what calculations are happening.
Right. We are not absolved of our responsibility in this. Yeah, that makes a ton of sense. And, frankly, we've seen even in some of the other topics that we've discussed, like lawsuits surrounding AI-based hiring, that you cannot absolve yourself of the responsibility as an employer. Just because you hire someone to do whatever that thing is does not mean that you are no longer responsible or obligated to follow the laws, for sure. And this is the Department of Labor too. So it makes me think about all of the government-based organizations, government contracted organizations that might be audited for these things. Because in my mind, when the Department of Labor is involved, you should just expect an audit. You should just expect that there's like a larger focus on compliance, because it's not, naturally we see this with anything, but when it comes down to state specific items, I feel like it's, of course there's exposure when you're not compliant. But it's a different ballgame when we're talking about something at the federal level.
Absolutely. And to your point about AI, I mean, the EEOC has issued a handful of opinions over the last couple of years, handful of notices, exactly to that point, that if you use AI in your hiring process, in your promotion process, in any part of the employee lifecycle process, you, the employer, not the vendor, are liable for any discrimination that occurs. And this is kind of the same approach.
Mm-hmm, mm-hmm. I do think that companies in general probably try their best to offload the responsibility and hire as many vendors as they possibly can to point fingers at, but you just can't. Frankly, I think this is a little bit of job stability for HR people out there, because the more regulation there is, the more involved people have to be. Like we see the downside to AI and some of these things, and needing human intervention, for example. And I do think that this is where, when HR professionals, especially business partners, generalists, managers, they are in the know with whatever might be going on, it builds a lot of credibility within a business, especially if someone's like an HR consultant or something like that. You got to know what's going on. Got to be in the scoop, in the know. Listen to the Policy Pulse episodes, and maybe everyone will be that much more informed.
That's right.
And speaking of the EEOC, perfect segue. The EEOC sued a staffing firm over male-only hiring requests. And I described this as a juicy story before we started recording. And I think it's juicy because these are just things that, are really fascinating to me. These types of lawsuits, or, whatever might be coming kind of to fruition. So the EEOC filed suit against a South Carolina staffing firm accused of honoring a client's male-only preference for laborer positions. The agency alleges that WorkSmart staffing excluded women based on client instructions, blocking qualified female candidates, and failing to train staff to resist unlawful demands. This is so fascinating to me, because it's like, how do you do that? How do you make such a dumb mistake to kind of go in that path? But at the same time, then I question myself, and I'm like, well, are there certain circumstances where you can say this is the preference? Obviously, you can't discriminate against someone else. So there's a lot of gray there. Anyway, walk us through it, Bryan.
I mean, I will say this, Traci, never underestimate the ability of people to be dumb, whether intentional or unintentional.
Totally. Totally.
So yeah,
Silly me.
this one's actually interesting to me because this one, the EEOC initiated this case itself. Usually, with an EEOC charge, there's an employee complaint that is filed with the EEOC. They investigate and then decide to take it further or to walk away. This was something where the commissioner saw this and filed a charge on their own. To me, that demonstrates sort of an aggressive approach. It also sort of puts staffing agencies on notice because they, in some cases, depending on the setup, this is not a broad brush, but depending on the setup, sometimes employment staffing agencies can be exposed to double liability. So this is something that HR absolutely needs to keep an eye on. This is something that I think anybody who's been through like HR 101 would be able to pump the brakes and say, wait, this is not something we can do. Right. But if you're in that situation, especially as a staffing agency, you want to train your recruiters, because a lot of times, even though recruiters are technically under the HR umbrella, they don't always get HR training. They don't always understand the nuances of HR itself. So that's important to make sure that recruiters are being trained. And then document it. Like everything in HR, right? We've talked about it ad nauseum, you and I. Document. If you feel like, as a recruiter, even you see something come across your desk that says we're only hiring males for this position, document that and say, this is not okay. I'm not okay with this. There's something wrong here. Pass it up the chain. And because again, that's where that double liability comes into play. The staffing agency, if they move forward with posting a job that says males only, or don't put it in the job posting, but weed out any female applicants during the initial screening process, that puts some potential liability on the staffing agency itself. So it's vital. It's important that that recruiters are trained on this type of stuff to at least be able to have sort of the base level knowledge of what's going on and know that, like, you can't say we're only hiring males for this position. There are some exceptions where, like, depending on job duties and things like that, there might be ways that that you might be able to exclude certain applicants because of their characteristics, but those are really thin exceptions.
Yeah, this was one of the things that I was thinking about. But before I get into that, because I have a whole, oops, I just touched my mic. We'll have to edit that out because it probably was like pop. 12:50. All right, we'll keep it going. So before I get into all of those thoughts that I have, one of the other thoughts in my mind, other than like, seriously, how can someone be so dumb, is that this is such poor judgment. Like, I would I would literally never hire the staffing agency because of this. It's so foolish. I mean, there intrinsically, you have to know that there's discrimination there, whether they like it or not. And then this is kind of what I was thinking about, and what I sort of alluded to in the beginning, is that we see job descriptions sometimes that say must be able to lift 50 pounds, must be able to, I don't know, must feel comfortable being in whatever circumstance. Like, I have a family member who is a probation officer, and she has to, like, observe when people provide urine samples, for example. And so as a woman, she is paired up with female, like, clients, as they call them, people who are on probation. And so one of the thoughts that I wondered about is, when there are moments where saying that you need a female probation officer or a male probation officer because of the clientele, because of the population, to reduce risk, for example, for them and the client, where that might come into play. But I would imagine that it's done in a much different way than don't interview female candidates, or we're not accepting female candidates. So that's the first thought, which I'm curious to hear your perspective on. And the second is like, as someone with a name that men have sometimes, like Tracy Morgan, for example, my name is Tracy, his name is Tracy. What there's a possibility that they're just completely discriminating against so many fronts because they see a name and they think they're just, it's just gendered, right? And it does make me think of an episode in the most recent season of And Just Like That, where this one character, Lisa, has an editor named Marion, and Marion is a guy. And it's like a blip of an episode where he's like, yeah, that's my name. Like, so what? It could be a girl's name too. And so I don't know. This is obviously lower on the risk standpoint, I guess, in terms of the discrimination that has happened with this staffing firm. But all in all, it's just really dumb. And I can't imagine how many people said, yeah, this is a good idea. But anyway, going back to this initial question around, or like circumstance where maybe it's okay to say that we need like females for this or males for that. Where does that kind of come up? Does it come up? Is it okay?
See, in that instance with probation officers, I would argue that you don't actually need to hire a female probation officer, but you may need female staff around. So like you wouldn't necessarily have to only hire female POs. You could hire, anyone
like
who's
a secretary
qualified,
or someone who can,
as long as someone can witness. It's kind of like when you go to the doctor's office and you have a male doctor, a female comes in during certain examination, like that, same type of thing. Like you just have a second person there. Especially if the patient or client requests it. It comes, so I think the best example for like exclusion for certain things is it's not exactly a one-to-one, but I think this will give people a good idea, is truck drivers. Anybody who has a DUI is immediately excluded. You cannot, you can't be a truck driver. And so that is a characteristic that someone has, and it excludes them from certain types of jobs. So I think that, like I said, the exceptions are thin. If we're painting a broad brush, we're going to say never say that this job requires only males or only females. It's important to make sure that you're evaluating people based on qualifications. And to your point about, being able to lift 50 pounds, sure, 70 years ago, that may have excluded females because, we aren't where we are today. And so only men would have been hired for jobs because you have to be able to lift 50 pounds. And because, women aren't strong enough to lift 50 pounds. They can't lift a box, right?
With two 30-pound toddlers, I can say I totally can lift 50 pounds.
I have no doubt. So that is kind of one of those that's like, it's one of those examples of like a very thin, a thin reason to exclude someone, which I don't think is legitimate. But there are some extremely minor exceptions like that, where people can be excluded based on specific characteristics.
Right. The DUI example is a good one. Yeah.
Yeah. Another quick, easy one would be somebody who's maybe in a wheelchair, and they can't, they too can't be a truck driver, unless there are, trucks that allow for like cars where you can drive if you don't have use of your legs, if trucks. Exactly.
Right.
So like there are, again, now we go back to some of the accommodations discussions that we've had in previous episodes where maybe there's an accommodation for someone who doesn't have the use of their legs to become a truck driver, that a court would say is a legitimate request. And, the employer has to allow that for the employee who's in a wheelchair. So there are minor exceptions where some things like that would come into play. But if you're looking at broad brush, don't ever say males only or females only.
Yeah. Extra emphasis on that. So dumb with a capital D. I don't understand. Well, the EEOC, I'm sure, had a field day with that, to your point, taking an aggressive approach. And it's wildly it's just wild to me, I should say, that no one complained. No one said, this is not legal or this is not cool, you
I think
know?
that goes to some of the training. I think that goes to some of the training that we've talked about.
Yeah.
Before I went out on my own, I was director of HR for a national staffing agency, and I mean, when I came in, I instituted HR training for all of the 30-ish recruiters that were in the office, um, because I saw that as a huge gap. That was a huge potential liability. So
Hmm.
we needed to have some training for at least, again, like we talked about, the base level knowledge of HR. What are the things that you just have to know? What's the
Yeah.
101 course?
Right. Don't discriminate.
Yeah.
Um, plain and simple, right? Um, and taking a little bit of a different approach here, California, we always come back to California. California is always on the docket for us, these episodes. So, California expanded pay transparency and equal pay liability. Governor Newsom signed Senate Bill 642, strengthening California's pay transparency and equal pay laws effective January 1st, 2026. So, in the next few months, employers must post a good faith pay range reflecting what they realistically expect to pay the selected candidate, not the broadest possible range. Some of these ranges, I mean, can we take a moment to say, like, you're not going to pay someone between $100,000 and $500,000. Like, let's be so for real. Anyway, the law also extends the statute of limitations for Equal Pay Act claims to 3 years. So just to, because my inflection was a little funny, the statute of limitations is extended to 3 years for any Equal Pay Act claims, allowing recovery for up to 6 years of violations. So this is really interesting. I definitely am going to pass to you, of course, this good faith pay range, which frankly, some businesses are not even posting pay ranges still, which is completely insane. Again, when we think about HR 101, like, you've got to know what's required. Your we talked about this, I think, last month. Your job post is reaching people outside of your own state. So you have to assume that people are going to apply outside of your own state that may or may not have pay transparency laws. You have to do the right thing. And I literally saw a role, I think it might have been like I don't know if it was like an HR business partner role or something, director, something. And it was $100,000 to $450,000. And I was like, is this a senior role or is this a junior role? Have you not decided? Are you doing this so that you have flexibility? Like, what? Because it's not that you can't pay above the range, it's that you should post the range that you expect to pay someone. And then obviously negotiations happen and sometimes you end up paying a little bit more, but you shouldn't be paying less. Anyway, Bryan, tell us what's going on here.
I think the simplest way to sort of distill this down is that California now says you can't put in a job description what you could pay an employee. You have to put in the job posting what you will pay the employee. And that can still be a range, but it has to be an accurate range. It's like you
Hmm.
said, 100,000 to 500,000 is not an accurate range. If it is an accurate range for your company, if you can make a legitimate business case for it, then you need to explain what goes into that. And that's part of where the California law redefines wages to include all those other things that we talked about earlier, like supplemental pay. It also includes bonuses, stock options, the supplemental pay, any allowances. Allowances would be things like ancillary benefits, like if you're a traveling salesperson, the company may pay for all of your gas. They may buy you a car. All of that needs to be calculated into these pay ranges so that there's an accurate pay range for people to look at, that is what you will actually be paying, not what you could maybe pay.
Hmm.
So why are we talking about California? One, like you said, it tends to be the leading voice on some of these things. But two, it's remote work. Like you also said, we're hiring people across state lines a lot more than we used to.
Hmm.
And employers need to be aware of this. If you're hiring nationwide, if you're hiring for a remote job, your job posting is going to be seen in California. You need to be compliant with the California job posting laws.
Right. So, just so I'm clear then, if let's say a job has the base range, generally speaking, and it's reasonable, the bonus and these other wages, then they can't just say bonus or stock. They have to say the amount. Like it has to actually explicitly state the number that maybe stock is not included in wages, but maybe it is if it's considered a benefit in some capacity. And maybe we'll get more clarity on that, because I think of California, I think of these companies that offer RSUs or ISOs. But bonuses, that's interesting, because usually you see base salary plus bonus, the range for the base salary and then plus bonus. And you don't have clarity on what that bonus is.
Yeah, and a lot of times, so you're right. California is now requiring that what wages will include all of that, bonuses, stock options, supplemental
Mm.
pay, all of that. So yes,
Oh yeah, you did
it can
say
be
stock options. I'm
it
sorry.
can be
Yes, stock
challenging.
options there.
Yeah, it can be challenging sometimes to calculate a bonus, but most companies that offer bonuses, um, whether it's to salespeople or for performance based, they have a cap on it. So you at least know what the cap is going to be on a bonus, so you can include that calculation in the wage range that you're putting in the
So you
job
can
posting.
just say like total, like
It's
the
total comp.
targeted, total comp, targeted earnings, and then it's rather than breaking it up based on salary and bonus. That interesting,
Exactly.
interesting.
I do think there's some confusion that will, sort of be
Yeah,
worked through over the next couple of years as this law takes effect, January 1st. So I think that yeah, I think there will be some clarification, whether through additional legislation in California or through courts in California, sort of putting some more definition around some of these things,
yeah,
like what's an acceptable range. Like if we don't, sure, we may have a cap on our bonuses, but we don't know exactly, the range for a bonus maybe could be like $200,000,
right.
depending on the position. So like that could be a big jump. Like maybe the total comp for this particular position with a $200,000 range of bonus could actually be like 300 to 500,000. Is that too much? Is that too much of a range, or is that
Interesting.
estimated
Yeah.
enough? So I think those are some questions that we'll see some answers to over the next couple of years. But I do think it's a step in the right direction, because, like to your point at the top of this discussion, it was we saw so many as these laws started to hit in different cities cities and states over the past few years. We saw a lot of that where companies would just put, okay, this job will pay between 90 and $900,000. Okay, thanks. Like that's not useful. So
Right.
I think trying to really scale this down and make it into a useful estimate, is an important step for a state to take to require employers to provide that for potential applicants.
Yeah. Um, it makes me think a little bit further about the stock options piece, which I'm sorry, I didn't, it like went right over my head when you talked about it before. Um, how does that work for private companies that don't share the costs of, or the value of a share? Like if they're putting it, say for example, in the total comp, then it's not really clear for the candidate that they're receiving stock unless it's explicitly stated that they receive stock and that it's part of this total comp kind of assessment. The other thing too is that a lot of companies argue that stock is part of total comp when you look at it on the broader scale, but not part of your targeted earnings. Because depending on if the company is public or not, you might not actually be able to cash in on any of your shares yet. So I just wonder how that will work.
Yeah, you're right, and there may be a vesting period.
Yeah.
I think that's part of the clarification that we'll see over the next couple of years
Yeah.
about, is that part of the compensation? Is that part of the wages as California has defined it? Because I could see sort of going in the other direction. I could see another option where employers simply stop offering stock options, or
Mm.
they only offer it after your third
After
year,
you've,
your fifth year. Yeah,
yeah.
something like that.
Oh, interesting. That'll be fascinating, especially when we think about like Silicon Valley and all of those tech startups. Like they really lean into stock options for attracting talent. That'll be very interesting. I'll have to find a few to kind of keep my eyes on and see what they're doing with their job postings. That's really interesting. Yeah, I guess we'll have to see how things shake out. But it is interesting from like a candidate perspective that then you have even more clarity, unless it's hard to even see the reasonable range really play out, because again, if the bonus is really high and then the stock options are really high, you could end up being in the same situation where you have this 90 to $900,000 pay range. Although unlikely, it could be like a $400,000 gap, $500,000 range, I should say. So it'll be interesting to see how that shakes out. Yeah. Um, our last kind of pulse, policy pulse item here is about the Supreme Court. So there are some major cases that could reshape HR. The Supreme Court's 2025-2026 term includes several cases that could dramatically alter how federal agencies regulate the workplace. The headline case, Trump versus Slaughter, challenges whether presidents can remove members of independent agencies like the FTC, NLRB, or EEOC without cause. The court will also hear Little versus Hecox, bans on transgender athletes, M&K Employee Solutions versus IAM Pension Fund, union pension liability, and Geo Group versus Monocle, a sovereign immunity for federal contractors. Two additional petitions, Cook County versus Nawara under the ADA, and Parker Hannafin versus Johnson under ERISA. Am I saying? I always question whether I should say it ERISA or ERISA, but I always say ERISA. Is that right? Yeah.
Yes.
They and they could also reach the court this term. So a lot of cases. A lot.
Yeah, yeah. I think this could be an interesting term for HR. I think that I mean, not to mention the country in general, but also for HR specifically. I think that right now it's we could, between our discussion today and when this pod drops, we could actually have some announcements on some of these cases. So we can come back and chat again next month if we do that. I think for me the most important one that HR needs to pay attention to is the Trump v. Slaughter, the one that challenges whether presidents can remove members of independent agencies without cause. Presidents, as the head of the executive branch, can remove employees of executive agencies, but they have to have cause for doing so. So essentially, this case, Trump v. Slaughter, is seeking to overturn a 1935 case that protects independent agency employees from removal by the president without cause. This would give the president far more control over these types of agencies, specifically for our conversation, the NLRB and the EEOC, which could mean wild swings every 4 years. You could see changes on labor law, on wage and hour priorities, like we've talked about earlier with the overtime calculation. You could even see some OSHA safety standards changing. I think that's the most important thing for HR to keep an eye on right now, is to see what happens with this case, not because private companies and HR are have people working in federal agencies, but because specifically the NLRB and the EEOC could be decimated overnight, and other people could be put in that have totally different priorities, taking the agencies in totally different directions. I think this will do, if this is overturned, and I don't know if it will be, but if the 1935 precedent is overturned, I think it will do two things. One, it will create those wild swings from an HR perspective that you won't know what to expect. And two, some states will fill that gap. Like we talked about, California, Washington, New York, Illinois, a handful of others. Those states at the state level will try and sort of counteract any of those wild swings and have more stability for employers and HR professionals, if that comes to be.
Right. Interesting. And the ERISA point too, it's so interesting because it's all about fiduciary plans, basically, right? Or fiduciaries, I should say. Um, and a lot of HR people probably don't even necessarily think about their fiduciary liability, whether they are managing um, plans for 401k or other types of pensions, not well, maybe pensions, but also any other types of retirement funds, or if they offload that. Like I mean, there's so much there. That plus the EEOC plus the National Labor Review Board. I mean, it's a lot, and we already have talked about the realities of being in HR and how we are already kind of in this like moment of whiplash. Like, okay, just tell us which way are we swinging here? So the idea of having more of a pendulum swing is a little bit terrifying. But we'll see, I guess, how it shakes out.
Yeah, we certainly will. And I think that also kind of says where we are, that like I didn't even touch on the ERISA stuff, which is hugely important.
Yeah.
And like you said, it's a massive potential fiduciary liability for employers that are offering those benefits. But that's where we are. That
Hmm.
like this huge issue is actually secondary to another even more massive potential issue from an
Yeah.
HR perspective. I think it's just it says a lot about where we are right now.
Yeah, totally. We're kind of just looking at the tip of the iceberg, and the iceberg is vast. Um, these are major agencies, major with like tons and tons and tons of oversight and uh, regulation and things that ultimately impact us every single day. So I don't look forward to any possibility of any of those major organizations having major changes necessarily from some of these cases that ultimately could really reshape the entire landscape of the workforce and workplaces. So thank you for giving us a taste of what may be to come. We will see. And I can't even believe it. This is October. So our next Policy Pulse will be November. And then we'll have probably one more after that before the end of the year, which is insane.
Whew, I know, right? How is it the middle of October? Like
Insane.
where has the time gone?
I know. I thought I mean, September felt like a really long month, but now October, it's just flying by. It's a flash of lightning. Well, Bryan, thank you again for another fabulous Policy Pulse segment. Thank you for being our resident expert in all things that could ultimately impact us very greatly. So for listeners out there, don't forget to take a look at the show notes so you can connect with Bryan. Maybe tap his shoulder if you need some support and you need to, maybe bring some resources onto your team. Bryan probably maybe is ready and available. I don't know, Bryan, I'm offering you up, but I have no idea what your availability looks like. But definitely connect with Bryan, connect with the show, connect with me, and we will see you next week for a regular episode, and then in a month, pretty much, for our next Policy Pulse episode. Thank you so much. Bye. Hey, just before you go, don't forget to subscribe to this show so that you are the first to hear when an episode drops each week. And maybe leave a 5-star review and a comment about how much you loved this episode. Plus, if you have someone in mind who would really enjoy this episode, make sure you share it with them. Thank you so much for tuning in, and I will see you next week.